Good morning, everyone. This is a continuation of the public hearing in Environmental Improvement Board case number 2412R regarding air permit emissions fees and construction permit fees. When we adjourned last evening, we were at that point where Mr. Prinz was cross-examining the mining association witnesses. I'm going to allow an opportunity for public comment, and then we'll return to that phase of the hearing. I did not see anybody on the sign-up sheet when I came in indicating they want to make a public comment. Is there anybody in the room now that would like to make a public comment? Okay, seeing none, is there anyone on the WebEx feed? Ms. Jones, have you gotten any indication? Yeah. Okay. Okay, and I'm not seeing any hands raised. So in that event, I'll just confirm we do have a quorum of the board present. We have Member Bitzer, Member Garcia, Member Ely, Chair Sweeney in the room, and I see Member Bitzer and Vice Chair Trujillo, I believe, on the WebEx feed. So we have all members present, and with that, we will proceed with Mr. Prinz.
Thank you. Good morning, Hearing Officer Virtue, Chair Sweeney, members of the board. And good morning, Ms. Burkisted. And thank you for your answers yesterday to the questions. And just have a few more this morning. So you're the environmental manager at Freeport-McMoRan, is that correct?
Yes, sir, for the Chino and Tyrone mines.
Okay, for the operations here in New Mexico.
Correct.
And in that role, you work with the Air Quality Bureau on a fairly frequent basis, correct?
Correct. When we have permit modifications and submitting reports, correct.
Okay. And in working with the Bureau, the Freeport has had a certain level of responsiveness and service by the Bureau. And hopefully it's been satisfactory for Freeport. If that level of service or responsiveness were to decrease due to, staffing issues, for example, would that not be potentially costly to Freeport's business here in New Mexico?
Potentially, yes. We really haven't had an issue with the permitting section. They've been great to work with, very responsive. But yeah, I mean, potentially, if we could get permits turned around faster, that's always a good thing.
Sure. Excuse me. Okay. Yeah. I mean, there's always probably room for to be more efficient. But if the Bureau were to be less efficient, well, that could be costly to Freeport-McMoRan, right?
Depends on what you're referring to when it comes to permit timeframes. Absolutely.
Okay. Excuse me. Let's try to think. I don't have any other questions
Well,
this
thank
morning, but thank you.
Okay. Do we have a redirect?
Mr. Hearing Officer, no redirect.
Okay, thank you. With that, we will excuse the. Oh, sorry about that. We'll go to board members.
I could use another cup of coffee too. Good morning. Good to see you all again. I just have a couple questions. Ms. Burt Keston, yeah. Yesterday you said, of that $8 million that the department plans to collect with, or hopes to collect with the proposal, that should not, probably doesn't include particulate matter. Can you say why you say that? It's not clear to me.
Sure. I did some back of the envelope calculations yesterday during the hearing. Again, before yesterday, we hadn't heard what the projected or hopeful revenue would be based on the proposed changes. So yesterday is the first time we heard the $8 million number. And there was also a comment that that was essentially just doubling the revenue from 2023. So I double checked Exhibit 51, and that looks correct. 2023 revenue was about 4 million. So you double that, $8 million. When you look at the fees that just Chino and Tyrone have paid, it's not just doubling, it's 8 times for Chino and approximately 3 times for Tyrone. So I also did a back calculation of how many tons of pollutants that $4 million must be based on just by dividing by $38. And so again, just back of the envelope calculation, it looks like it's a simple doubling of 2023 emissions, which did not include particulate. And Chino and Tyrone together, particulate alone is $500,000. So that's the other reason I'm thinking they must not have included our particulate, and assuming they didn't include particulate for any other source in New Mexico either.
And then I'm trying to understand the transition from TSP, total suspended particulates, the former state standard that was retracted by the board in 2017, and PM. So it makes sense if the department was charging for TSP, they no longer are, that they charge for the replacement of that, which is PM10 and 25, I assume. What did you pay prior to 2017 for your TSP emissions? Do you remember any or have a sense of what your TSP emissions were prior to the retraction of the state standard?
I would have to go back and look at those old invoices again. We also made some pretty big changes to our permit between that time and now. So I'm pretty sure our TSP allowables were lower at that time, but I'd have to go back and look and see what it was.
That's fine. Thank you very much. That's all.
Member Garcia.
Yes, thank you. Thank you, Mr. Hearing Officer. And thank you for your testimony today. I just have a couple of questions for you. Regarding the March 8th stakeholder meeting that you said you attended, could you tell me how many other, I looked at the list in the chart that NMED provided that showed a list of folks who attended. I couldn't tell. I could recognize a few of the staff names in the list, but I couldn't tell who represented what entity. So could you give me an idea of who was represented by industry in that meeting?
Sure. So I did the same thing. I looked at the list that you could pull after the meeting. It was actually on March 20. And I don't know the other industries that were represented there. I remember there were 10 or less that were not agency affiliated in that meeting, but the information didn't provide who everyone was associated with. Even my name, I think, just says Sherry. It didn't say.
Right. Okay.
Yeah.
Okay. Thanks. And also, you made the point that that meeting took place after the NMED had already petitioned with their draft rule change to the
Correct.
board. Did they give you an opportunity to make comments? And were there very many comments made in that meeting?
There was an opportunity for comments in the meeting. I did ask one question. I don't think I framed it very well. I did ask one question. I don't remember anyone else asking questions in that meeting. It was all over in about 30 minutes.
Okay, and how much time before that meeting did you get a copy of the draft rules?
I think it came out on March 7. Is that right? Yeah, I'm pretty sure it came out on March 7 and the meeting was on March 20,
Okay,
but I'd have to double check.
okay, thank you. And my next question is regarding your, you submitted some proposed rules, which are actually saying don't change anything except for the part 71.114, which you would like to add a periodic review. Is that correct? And that's the only difference in your copy, other than keep everything the same and then add that periodic review? Am I reading that correctly?
Yes, that's mostly correct. We also did agree with NMED's proposal to do some housekeeping items like allowing them to take electronic payment and things like that.
Okay.
But yeah, we did add the 14. Yeah,
Okay. Okay. Thank you. That's all I have.
thank you.
Any other members? Member Bitzer, Vice Chair Trujillo, do you have any questions? Not seeing anybody's hand come up. Chair Sweeney? Okay, so that appears to conclude the questioning from board members. I'll ask Mr. Molenberg if he has any redirect based upon the questions the board members had.
Mr. Hearing Officer, no redirect.
Okay. With that, I think we are at that point where we can excuse the mining association witnesses. Thank you for your testimony. That brings us to the Independent Petroleum Association, which has one witness, Mr. Rose. I saw her earlier. Hey, thanks. Not that I missed just to like her. Oh, yes.
Mr. Hearing Officer, when you're ready.
You may proceed.
Thank you. And we'll try to figure out how far, whether I can stay this far or how much further I can get so you can hear it. Again, for the record. An arrival. I don't know, Mr. Hearing Officer, we should probably wait for the board member to get seated.
We will
before
wait a
starting.
second for Vice Chair Trujillo to be seated. Vice Chair Trujillo, we just finished with the Mining Association witnesses, and we are now beginning the Independent Petroleum Association witnesses. Witness, what is one witness?
Oh, yes, sir. Actually, I was on, I heard everything.
Okay,
So,
great,
yeah.
great. Good.
So are we ready?
Yes.
Thank you, Mr. Hearing Officer. Again, for the record, my name is Louis Rose. I'm an attorney with Montgomery and Andrews. I'm here representing the Independent Petroleum Association of New Mexico. And I reserved my opening statement until now. And I just have a brief opening statement, and then we have one witness Mr. Winchester, who's the executive director, who submitted what we believe to be non-technical public comment, but we're making him available for questioning from the agency and the board. Mr. Harris, or members of the board, we're here to, and I want to remind you about the statutory basis for the proposal. And there's been a bunch of discussion around some of these terms, but let me refer you to the statute. That's the Air Quality Control Act, section 74-2-7B, and it's B6 and 7. B6 requires the board to adopt a schedule of construction permit fees sufficient to cover the reasonable costs of A, reviewing and acting upon any application for such permit, and B, implementing and enforcing the terms and conditions of the permit, excluding any court costs or other costs associated with an enforcement action. And that'll become apparent when we submit closing arguments as to what, but based on our initial review of the department's proposal, we have questions about whether parts of it satisfy the schedule requirement. That term has been defined by the Court of Appeals in the context of the Mining Act, and we believe that some of the proposal doesn't meet that criteria. It has to be sufficient to cover the reasonable cost, and you heard discussions yesterday about what constitutes reasonable cost, what sufficiency means. And we believe that based on the evidence that the agency has not established, that the current fees aren't sufficient to cover the reasonable costs of reviewing and acting upon such permits and enforcing such permits. You heard some discussion yesterday about the department's proposal to recoup, in their words, compliance costs or the costs of enforcing permit conditions or rules against the regulated community. I don't remind you that statute precludes you from including costs, any court cost or other costs associated with an enforcement action in the fees that you're required to adopt. So we have some questions and believe that the fee request is not consistent with this provision, at least as to recoup compliance costs. B7 requires you to adopt a schedule of fees consistent with the provision of section 502B3 of the 1990 amendments of the Federal Act. And that's the Title V permit program. And so you basically have to look to 502B3 of the Federal Act to determine what fees are you allowed to charge and whether it's consistent. And you've heard a substantial discussion on that. In terms of IPNM and its members, the bulk of which are small independent producers, we're really talking about the construction permit program. There may be some Title V permits included, but most of the members have, to the extent that they've expressed concern, it's been over the construction permit program, particularly what looks like a 5-fold increase in the costs associated or the fees associated with the GCP program, at least for oil and gas facilities. And you have a copy of GCP oil and gas in the materials. There are other GCPs, or at least one other GCP that applies to oil and gas facilities, which are not included in the materials, but the bulk of the permitting that's done for most of the independent producers members is construction permits, and particularly the general construction permit program. You've also heard discussion that the permit on its face does not apply in non-attainment areas, and I think you heard substantial discussions during your hearings on the ozone precursor rules about non-attainment in Lee and Eddy and potentially in Chavez County and what that might mean with respect to these facilities. So in the absence of the GCPs applying, any construction permit, and we're talking about sources with a potential emission rate of greater than 10 pounds an hour of any pollutant, fee pollutant, or 25 tons per year. And we're mostly talking about combustion equipment at these facilities. And so to the extent that construction requires, and it's pre-construction, and no construction can occur before the permit's issued. So timing is of substantial concern. And obviously, the sooner the agency can get to and review and grant the permits, I think the more our members would be happy. The department is represented that they're meeting their deadlines. From experience, I think that's primarily true, but in any case where a public hearing's been requested and granted, those deadlines have not been met, and under the agency's permit procedures for hearings, if you look at the process, which applies to not just air permit hearings, but also solid waste hearings, hazardous waste permit hearings, and others, the process takes approximately 4 to 6 months to complete, just to if you lay out the timelines that are in the rule. So with a 180-day deadline or action under the AIR Act, that's with an extension to allow for a public hearing. And normally those decisions aren't made except at the end of the first 90 days. There's no way the department under the current rules can meet the deadline for any permit application that requires a public hearing. So that's something that perhaps the agency should look at its rules and see whether it can create or adopt procedures that may expedite the permit process. But under the current regime, permits requiring public hearings by necessity cannot meet the deadline in the statute. And as we pointed out in Mr. Winchester's public statement, primary concern has been over the process, and we've talked about what pre-petition public involvement there's been in the proposal, and I think at this point the answer is none. There's been some post-petition discussions, but mostly on an ad hoc basis, and it's fairly clear and that the justification for the increase, at least the documentation and the support for the increase, wasn't really available until the department filed its direct testimony in this proceeding and attached exhibits. And as we pointed out yesterday, one of the primary exhibits, the ERM or ERG memorandum, wasn't available until the submittal of the case in chief, and the details of the assumptions going into that memorandum were not available at all. Some of those were discussed yesterday, but as to confronting the details, IPNM has not been, it's not been available for IPNM to mount a challenge. In fact, the time frame between the submittal of the case in chief and the rebuttal testimony was something like 10 days to 2 weeks, and that's an insignificant amount of time to really get a substantial case together in technical opposition to the proposal. And quite frankly, we're still not aware of the justification other than the discussion yesterday about the department spending as much time reviewing GCP applications as it does for normal NSR permits under Part 72. That was news to us based on our experience and discussions with the consultants that do some of the work for IPNM members. We've got a completely different explanation of the time required. So, but unable to test the department's recitation of the reasons, there's not been sufficient time to do that. So the fact that IPNM has not put together a technical case doesn't mean we agree with the proposal or agree with the technical basis for the proposal. It just means there's been insignificant or insufficient time to actually prepare and submit a case in opposition to the proposal. In addition to the process, we believe that the proceeding in front of you is premature. And as we've outlined in Mr. Winchester's testimony, we believe that the process for the department's proposed expansion, that's the basis for the fee increase, needs to be vetted first with the executive in the process of preparing budget requests and authorization for hiring additional FTEs, and ultimately with the legislature and the legislative budget process. That has not been done. And at this point, there's no approval by the legislature of the increased funding or the increased personnel. And we believe that what we're dealing with here is putting the cart before the horse, as you will, that their proposal in terms of staff needs and even IT needs to be vetted with the appropriate agencies and with the legislature before coming to you to figure out a fee schedule to fund that requirement. And we believe that the appropriate action here should be to not grant the request and basically counsel the department to go through the process before coming back to you with a proposal that meets the requirements and has the auspices of the legislature in terms of both the funding and the staffing for the program. And that really, the decision on as to what the program needs to look like, what staffing and what funding is appropriate, needs to be a legislative decision, not a board decision. And with that's our position, Mr. Hearing Officer, members of the board. And we'll expound on some of these issues in our closing arguments, which will be submitted. I guess it'll be the end of July or the first part of August, depending on when we actually finish this. As I indicated, we have one witness. Our witness is Mr. James Winchester, who's the CEO or executive director of the IPA&M. He submitted written public comments to the board, and if the board wishes, I can have Mr. Winchester sworn and summarize that written submittal, and he can stand for questions. It's up to the board. Mr. Winchester's here to be available, but again, this is in the nature of public comment, not technical testimony. Mr. Hearing Officer, if you will.
Okay. Mr. Winchester, if you just identify yourself and spell your name, we'll have you sworn in.
Certainly. My name is Jim Winchester, Winchester, Executive Director, Independent Petroleum Association of New Mexico. I do.
And Mr. Winchester, did you submit written comment to the board in this proceeding?
Yes, I did.
Could you, and that's already been admitted as part of the record, it's my understanding. Mr. Winchester, could you briefly summarize your statement?
Certainly. First of all, Mr. Hearing Officer, Madam Chair, members of the committee, thank you for the opportunity to be here today on this very important topic to our members. Again, just as an introduction, my name is Jim Winchester, Executive Director, as I mentioned, of the Independent Petroleum Association of New Mexico, frequently referred to as IPA&M. Previously served here in the state of New Mexico as the Communications Director for both the New Mexico Energy, Minerals, and Natural Resources Department and the New Mexico Environment Department for 4 years. I went on to work for the city of Boulder before returning here in 2017 to work in my current role. Just a little bit of background, IPA&M actively works to protect, defend, and promote the responsible oil and gas production of our members here in New Mexico. And this work does include working with the agencies, with legislatures, with the regulators who oversee this important industry. When necessary, IPA&M will litigate against rules that we believe disregard due process or constitute regulatory overreach. Now, the majority of our members at IPA&M are New Mexico-based companies, and a lot of them are relatively small. In that sense, IPA&M represents New Mexico businesses, owners, operators, workers, and families who are here in the state that are directly impacted by the issues that are related to the industry. In general, our members are responsible for tens of thousands of oil and gas wells and related facilities in the state, and we represent hundreds of thousands of acres of oil and gas interests in the state. As Mr. Rose mentioned, we have submitted non-technical written comments on behalf of myself, and I will just briefly highlight some of those comments for you and then be open for questions. First of all, I want to make extremely clear that IPA&M is not against regulations, and we also understand the need at times to increase fees that are proportional. IPA&M notes that while base fee amounts for the construction permits have not changed for several years, this board's regulations require that the NMED adjust fee amounts based on the consumer price index, as we've heard. And this is per 20.2.75.11F and 20.2.71.112.E, all in the New Mexico Administrative Code. And these fee adjustments are announced each year on the department's website. The current Title V fee per pollutant is $38.47 per ton. The corresponding Title V HAP fee is $244.51. This is based on our last review of the Environment Department's webpage just within the past week. The Environment Department's fee proposal discussed yesterday and today would raise, as you know, the construction permit fees and the operating permit fees. Initially, when we heard about this, my members raised concerns right off the bat about the lack of public and regulated entity involvement in preparing the proposal prior to its submittal. In the past, I will say that the Air Quality Bureau has done a good job engaging the public and the regulated entities in extensive pre-petition meetings to discuss the program needs, as well as those needs for revenue and the possible options that are out there available to achieving those revenues. We certainly want to see a department that is efficient and well-staffed. As a result, in these past cases, even with the Independent Petroleum Association of New Mexico, some of these proposals have been met by us with little or no opposition. In this case, I think as you've heard, the Environment Department departed from these past successful processes and instead chose to submit a proposal before discussing it with the regulated entities, including oil and gas companies that will be the subject to these substantial fee increases. So from that standpoint, IPA&M urges this board to requiring a more substantial public process prior to deciding whether or not to adopt the proposal in some form or fashion. Now, IPA&M notes that the fees collected for these permits are deposited into the Air Quality Permit Fund, created for purposes specifically outlined in Section 74.2.15B. Based on our review of the relevant information, IPA&M notes that the funds for each program have substantial balances into the tens of millions of dollars. Given the current balance and the expected income from the existing fee requirements, IPA&M respectfully asserts that the Environment Department is not justified right now in the need for fee increases at this time. To the extent that the fee proposals will generate income beyond that what is necessary for administering the current program, it is our very strong belief that the fees amount to an impermissible tax on air emission sources, including those in the oil and gas business. To be clear, the Environment Department proposes to increase the fees paid for oil and gas facilities for general construction permits by 500%. Specifically, the fees for the GCP permits would increase from $5,100 to $25,500 with no changes to the permits or required review. IPM has not seen any justification for this proposed increase. Now, we do concede that the number of permit applications may have substantially increased over the past several years. IPM understands that the Air Quality Bureau's own review of those applications, however, has not substantially increased in terms of their process. Under the applicable general permits, the Air Quality Bureau's review is limited to whether the proposed source includes emission units or emission rates beyond those authorized by the general construction permit. No source-specific regulatory review or modeling is conducted, nor is the ABQ authorized to propose monitoring, record-keeping, and reporting requirements beyond those specified in the general construction permits. Now, based on IPM's members' experience requesting general construction permits, IPM believes that the required review of these applications should take no more than a day or so to complete. As such, $25,500 seems well beyond the amount necessary to pay the reasonable costs of reviewing permit applications. IPM has seen no evidence that other activities, such as permit review and update, document development, and other appropriated review activities exist. IPM notes that in section 74.2.12b, that it limits the use of permit fees collected for any court costs or other costs associated with any enforcement action. Additionally, IPM is concerned that the Air Quality Bureau is currently applying and will continue to apply the general construction permit fees to changes or modifications at sites in which our members are replacing authorized compression or other emission sources. Those changes do not modify the permit conditions. They only delineate the equipment authorized to operate under the permit. Review of these notices, again, is very limited in verifying that the replacement equipment is authorized by the permit. And we are not even clear, but we certainly are concerned that those reviews for modifications certainly does not justify a $25,500 permit fee for every modification. And again, to this date, we're still not clear whether or not that will be the case. IPM notes that because of the existing supply chain issues affecting the ability of certain equipment and the needs to increase compression over the life of most new oil and gas wells, that an operator may in fact need to replace that compression and other equipment a number of times over the life of the well. Again, those changes do not warrant the fees that are now being proposed. Moreover, IPM does not believe that those notices constitute provision revisions under 20.272.219 in the New Mexico Administrative Code, warranting the application of those fees. If the board decides to revise the construction permit fees, it should at least clarify that notices of equipment changes within those authorized by the general permit are not subject to fee requirements. So for these reasons, and for many more stated above, our association urges the board to, for the time being now, reject this proposal, request that the agency engage in meaningful discussions with all affected parties before proceeding with the revised proposal. Thank you for your time, and I will stand for questions.
Mr. Herringhouse, I have no questions for this witness, and we turn him over to examination.
Okay. We'll go in the same order that we've been going in. Mr. Vollenberg, do you have any questions for this witness?
Mr. Hearing Officer, no questions.
Okay. Mr. Prinz, you have questions of Mr. Winchester?
Good morning, Mr. Winchester.
Good morning.
I do just have a few questions. So IPA&M represents many of the smaller operators in the industry, correct?
Yes, correct.
And do you know how many of your members qualify for the Air Bureau Small Business Assistance Program?
I don't have that direct information. And in fact, a lot of those companies are privately owned and they do not disclose that. That's their own prerogative and their own business and working directly with the state.
And you are aware that there is a small business discount in the Part 75, I believe, correct?
This is in regards to the methane rules that were promulgated within the last year and a half. Is that correct?
I don't think it's in regard to the methane rules. I think it's in just the fee provisions, the fee schedule, but you know,
I can try to track it down. I think it's in part of your material somewhere. I can find it.
So I will answer the question from the standpoint that I don't specifically know the parameters of those available discounts in the existing code. I will say that, and we are very appreciative of the fact that the Environment Department in a lot of the rules that have been promulgated recently do have small operator provisions. However, as we countered in those hearings, they would not capture many, if any, of our small operators because they are too small. I will also cede to Mr. Rose if he has those provisions.
Mr. Rose, Mr. Hearing Officer, it's in 20.2.75.11C NMAC.
And that's where I was headed.
And Mr. Rose, the definition for small business is paragraph F under definitions.
Yeah, thank you for drawing that to my particular attention. I am certain that my small businesses are aware of it.
Thank you. And you, in your testimony, you state that IPA&M believes that you know the increase in the fee has not been justified because it seems IPA&M feels that the amount of time that it takes to process a permit was, I think you said 1 day.
That is a characterization made by memberships. Members explained to me. I do not report that to be technical testimony. I will also say that additional factors into our concerns of non-justification are really centered around the lack of transparency on the part of the department as to why these fees are needed.
Okay. And as you heard yesterday, some of the testimony about some of the new regulations that have been adopted over the last 20 years, such as federal air regulations, 40 CFR 60, Part Quad A, Quad B, for example, as well as Part 50. Part 50 will adopted by this board 2 years ago. So you would agree that there have been regulatory changes over the last 20 years that would create new regulations or actually create more work for the Bureau or additional work in the permitting process, correct?
Certainly, and I'm more than willing to concede that if the department is willing to concede that those costs are passed on to our members and create substantial more work for them, specifically the smaller companies who don't have large staffs and resources to fully keep up to date at all circumstances at all times. We're currently in the midst of 13 different rulemaking hearings between the state and the federal agencies right now. And our job as an association is to make sure our members are informed of that.
And there have been, over the last 10 years in particular, there have been new technology in the field with horizontal drilling and hydraulic fracturing, correct?
Absolutely. I think that's something that the industry is very proud to point to, which has gone into decreasing emissions while increasing production at the same time.
But isn't it fair to say that some of those technological advances have also made permitting or the permits a little more technically complex?
For sure. Absolutely.
But those technological advances are also a large part of why New Mexico has become the second largest producer now in the country, correct? Because
Certainly.
we can access stuff in the ground that it was just not economically feasible to access.
Certainly. And again, the fact that we are able to do that by creating less of an environmental footprint, releasing fewer emissions, I think is something that is extremely important to us and our members.
And have you had a chance to review this, look at this demonstrative exhibit on the permitting process at all?
I've given it a glance, yes.
And would you agree with all the processes that are outlined in this demonstrative exhibit?
Without being a regulatory expert, as a lot of my member companies are, I personally do not necessarily know fully what that process entails. That exhibit, I'm sure, is what the department is conceding is accurate.
Thank you. I have no further questions.
Thank you.
Okay, cool. Go to questions from board members.
Just one quick one, Mr. Winchester. Did you say that none of your members are Title V sources? Did I get that right?
Excuse me?
Are any of your members Title V sources? Do they meet the threshold for a Title V permit?
Yes, I believe we do have members that do meet that threshold. While we represent independent producers and the majority of our members are in the neighborhood of 12 employees, we do have larger independents that are part of our association. And I will also say we have majors that are part of our association. However, those majors, through our bylaws, are not allowed to sit on our board of directors. We are strictly focused on independence. If they join our association, they are joining the overall effort of industry.
Okay, that's all. Thank you.
Okay, thank you.
Any other questions from board members? Vice Chair Trujillo.
Here we go. Thank you. I just wanted to follow up on some questions that Member Garcia had asked previously. And so I'm curious, was your association engaged in discussions with NMED about potential rule changes prior to the petition or hearing?
We have been involved in prior rulemaking hearings with discussions with the agency, including the methane rule that was promulgated in front of this board.
Oh, I'm sorry, specifically this particular topic.
No, our first notice of this rule coming before this board was when it was filed in March, the same time that you all received it.
And did you attend the public meeting held for this event or for this topic?
I did not. The petition that was filed in this particular case was not brought to my individual attention until after that had occurred, at which time we then hired Mr. Rose to represent us in this case. He did reach out to Secretary Kenny, and I do believe he and the New Mexico Mining Association had a sit down to express our concerns. I will let Mr. Rose explain the outcome of that sit down, but to my understanding, all of our requests for delays or further consideration were denied.
So just from my understanding of the situation, what you are asking for, what you hope to gain from this is that you just want more discussion with NMED about future fee changes, that you're, as an organization, not opposed to fee changes in the future?
No, I think just to clarify, and I appreciate the question, we believe this particular fee increase is exorbitant and not justified. We believe that the board needs to pause this hearing to allow time for the agencies to put together a stakeholder group to discuss these issues so that our members specifically can illustrate the financial impacts that will occur to them. The concern in general right now within the independent producing community is that there are fewer and fewer of us. While production is increasing in New Mexico, and we're the second largest producer in the state, the number of active producers in New Mexico is decreasing. In other words, the top 10 producers are getting bigger, whereas the smaller ones are not able to stay in business because of the high costs of overregulation that are occurring at all levels of government.
Well, thank you for kind of bringing that background. And that's all I have. Thank you.
Thank you.
Any other questions from board members? Member Bitzer, you have any questions? Not seeing your hand up.
Do not. Thank you.
Okay, thank you. Mr. Rose, you have redirect.
No questions, Mayor, Mr. Hearing Officer. Just as a response to Mr. Winchester, I think Director Miano discussed the agency's actions yesterday in response to me. So I think you can look in the record and see what the process was and what the agency's response to those discussions were. At one point of clarification before we leave, Mr. Hearing Officer, and that is, it wasn't clear to me on your admission of exhibits, you admitted demonstrative exhibits. My understanding of the rules are that those were meant to be even though they're admitted, they're not really evidence in terms of the board's consideration. They're demonstrations based on evidence in the record otherwise. And at least historically, they've never been admitted as a substantive exhibit. And I wasn't sure if your ruling would then make them evidence we can refer to in closing arguments, or how you want to look at that.
Mr. Rose, I have, in hearings I've conducted, admitted demonstrative exhibits, not as evidence, but as a reference to the evidence that has been previously submitted. Just my own personal view that it's helpful to have that for purposes of being able to refer to what was in that exhibit, but it needs to be tied back to technical evidence. It's not, my articulation of that would be, it's not separate freestanding evidence. And when it's cited, it needs to be referenced back to technical evidence that was submitted.
Thank you, Mr. Hearing Officer. That's consistent with my understanding as well. I just wanted to, because your ruling didn't clarify that, just wanted to make sure that was clear before we go into submitting post-hearing submittals.
Okay, well, thank you for that. I hope folks understand the basis for what was done. And I hope it will be helpful to people when we proceed to closing arguments and submittals.
Thank you, Mr. Hearing Officer. That completes our case.
Okay, I believe that concludes the evidentiary portion of the hearing. Does anyone have any administrative matters to bring to the attention of myself and the board at this point in time? If not, we'll go and do a review of the closure of the record and post-hearing submittals.
Mr. Hearing Officer, I have heard perhaps that there are others on the platform who might want to make some public comments at this time.
Okay, I will, will then go back into public comment. Ms. Jones, do you have indications from anybody that they want to make a statement? Yeah. If there's anyone on the platform that would like to make a public comment, would you please state your name?
George Munoz.
Anyone like to make, I'm sorry, I was George Munoz. Okay, Mr. Munoz, would you please state your name and proceed to make your comment?
George Munoz, State Senator, Senate District 4, Gallup, New Mexico. My comment is to the agency and to the hearing is,
Yeah.
we've never
Senator
heard
Munoz, if
any.
we just briefly, we need to swear you in under our rules. Do you swear to tell
Under
the truth,
public
the whole
comment?
truth, and nothing but the truth?
Let me ask one question first. Isn't this a public comment sector? Everybody's being sworn in for public comment?
That's correct.
Okay.
Under our rules, the public commenters need to be sworn.
Yep, that's fine.
Okay.
So I do.
Okay, thank you.
Thank you.
Proceed.
Thank you. I mean, we all know that things and costs are increasing throughout the state. Through the last legislative session, we've heard about fee increases and costs. This fund has never been one of those funds that's been discussed in hearings that I've been in or in meetings with the cabinet secretary prior to this hearing. This would take this state agency to about 550 people. You're asking for an increase of 110 employees. The legislature still has to appropriate the money out of the fund to the Environment Department to do that. The state is currently going through a pay study that this was never included in any pay study across the board in the state for 110 additional employees at the Environment Department. We know that there was 2% CPIs annually on this fund to increase the costs. We know the feds are requesting more money, but we've come to a point where I think we're over collecting. The fund has never requested more than what it had to make itself operational. We've made those transfers and never had a deficiency in that fund since I've been the chair of Senate Finance. And so we understand you want to increase operational side. We think this goes way and beyond, almost tripling the fees in the fund, going from an $8 million to $30 million fund. Just doesn't make a lot of sense. There was some testimony yesterday that I watched, some hard questions, some good questions that were answered. But let's be a little bit rational in the room. And if we're going to increase fees and costs, we need a justification. We need to know the amount of employees. Well, we know that number, 110 employees. I don't know where you're going to get those today. If the Environment Department knew they were going to do this in this last year, and it's still continuing, those 110 employees should have been in the pay study. What's their cost? What are they going to do? What does it cost for this attorney in this division? How many you're going to need? And we could have got appropriate numbers and understood the justification for the increase. But at this point, it seems to me like we're just going out for an increase. We're shooting in the dark and saying we're going to get 110 people and we're going to help some air quality stuff, which I don't have a problem with. But I think we need a little more justification in what you're trying to do because the legislature will have to make those fund transfers. So Thank you for your time.
Thank you, Senator Munoz. Do we have anyone else on the WebEx feed that wishes to make public comment at this point?
Mr. Hearing Officer, if I might, we've gotten word that there are at least 5 people who are willing to make comments or still looking to try to figure out how to do it. And so I don't know whether they're on the platform or whether they're looking for a call-in number, but at least that's what we're being told, is that they're having difficulties getting on and make those comments.
Ms. Jones, do you have any requests for public comment?
I'd like to make a comment. My name is Jocelyn Compton.
And I guess, is there a phone number they can call in on as opposed to being on the WebEx platform, or do they have to be signed in on the WebEx platform to give testimony? It'd probably be helpful if you could announce the number. And if they decide to join, fine. If not, that's fine too.
Okay, well, let's announce the call-in number, Ms. Jones, so folks can call in, and then I'll go to the person who has indicated it's already on the platform now.
Oh, okay. If the number is 1-415-655-0001, and the access code is 2633-838-7926.
Okay. I'm told we have another person on the platform at this point who would like to make a public comment. Would you please identify yourself and we'll swear you in?
My name is Jocelyn Compton. I work for Santo Petroleum.
Okay, can you spell your name for the record, Ms. Compton?
JOCELYNCOMPTON.
Thank you. You, where you'll tell the truth, the whole truth, and nothing but the truth.
I do.
Okay, please proceed.
Members of the Environmental Improvement Board, my name is Jocelyn Compton. I am a reservoir engineer with Santo Petroleum. We proudly work in New Mexico. We recently celebrated 100 years of responsible oil and gas production in Artesia, New Mexico. It's my understanding that the Environmental Department fee proposal discussed today would raise both the construction permit fees and the operating permit fees. And I have serious concerns about this increase due to both the fee increase, the lack of transparency, and the lack of due process. I work for a small company, but it's not small enough to meet the requirement for small operators. The department proposes to increase the fee paid for oil and gas facilities for general construction permits by 500%. This hits small producers like the company I work for the hardest, and it will continue to lead to our demise inflicted on the part of regulators. I work, like I said, for a very small company. In the past, we have had to pay exorbitant costs to hire experts to help us draft and file our air permits. And it was a significant cost for our small company. And now on top of this, the NMED is proposing a ridiculously high fee increase from $5,100 to over $25,000 for general construction permits. This is a 5-fold increase. It just seems to me way out of line. To my understanding, the funds used to administer the NMED program have substantial balances into the tens of millions. I saw a presentation by economist Jenner Fabian to the New Mexico Legislative Finance Committee on June 11th, 2024, that noted that total oil and gas revenues to the state have more than quadrupled in 5 years. And here the NMD is proposing an immediate 5-fold increase. It just seems way out of line. The fees seem to be a tax on air emissions, particularly targeting oil and gas industry. For the reasons stated above, I urge the board to reject NMED's fee proposal and to do this with the correct way, with executive and legislative authority, with input from the impacted parties, like small companies such as the one I work for, and with transparency on the motives for raising these millions of dollars. Thank you.
Thank you, Ms. Compton. Ms. Jones, do we have anybody else? Platform?
Is there anyone else on the platform that would like to make a public comment? We do have 2 call-in numbers.
Okay, can you just call on one of them?
Call-in user 3, if you'd like to make a comment, would you please speak up? Call-in user 4. If you're on the platform and you can hear me and you'd like to make public comment, please speak up.
Yes, this is Representative Tim Townsend. Can you hear me?
I can, if you could
Yes,
speak
we
a little
can.
bit louder.
Yes, thank you for the opportunity to comment. I have been trying.
Representative Townsend,
repeated-
I need to swear you in under our rules.
Okay,
We're hearing. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I certainly do.
Okay, thank you. Yeah, would you spell your name for our court reporter if you would too also?
You bet. It is J-I-M, last name Townsend, Townsend.
Okay, thank you.
Thank
Proceed.
you, sir. Yes, sir. I have served in the legislature for 10 years, and for the first few years, I served on House Appropriations. House Appropriations has a process, a long-standing process, where department secretaries bring to House Appropriation their plans and their needs for budgeting in the upcoming year. Part of that process is to approve full-time employees, FTEs, and in many cases, approve that those full-time positions are, quite frankly, used in a manner to balance their budget when they don't fill the positions, but yet they're funded. I'm very concerned with a 500% increase, circumventing the long-standing legislative process that has been used and verified year after year. If the department has a need, they should go through the process of a bill being drafted, their secretary presenting that to the House Appropriations. That plan then is either approved or denied. If they don't like that process, they can bring a bill forward to the governor and have that bill go through committees and, of course, the both chambers. This process is astonishing to me, that we are circumventing a long-standing process of approval and trying to target a precedent that will not be good for the legislature of the state of New Mexico. I oppose the process. I do not believe it's fair, and I don't believe it's a precedent that the state wants to set. And for those reasons, I urge this body to not approve this rate increase and to make the department follow longstanding traditions and rules that they have utilized for years and years. Thank you very much.
Thank you, Representative Townsend. Ms. Jones, do we have any other folks?
If there's anyone on the platform that would like to make public comment, now is your opportunity. Simply speak up and give us your name.
Mr. Hearing Officer,
Yes.
this is Leslie Padilla, EIB Council. I just wanted to make sure everyone was aware, because this happened to me. When I logged into the meeting on WebEx today, I used the link that had been in the agenda, not the link on the EIB's website, and I wasn't able to join the meeting. I finally realized my error and went to the link on the EIB's website. There were some other people in that waiting room. So I'm concerned there may be other people who had perhaps wished to make public comment, but aren't aware that we were using the incorrect meeting link.
Okay, well, let's do this. Let's hopefully Mr. Rose, you and Mr. Winchester could notify whoever you've been in contact with of the link on the website. And then Ms. Jones has given the phone number to folks. So we'll take like a 5-minute or so break here, allow you to contact the folks who are having trouble, and we'll come back in 5 minutes and proceed. Thank you. Okay, we're ready to go back on the record. Yeah. Okay, we're back on the record now, and for the record, I've asked Ms. Jones to explain how the link situation has been addressed and how it's working. Ms. Jones?
Hi, yes, thank you, hearing officer. There were 2 links that had been published. And knowing that yesterday at the beginning of the hearing, I've had both meetings open. And as folks went into the meeting, the original link, I was directing them to this meeting. We've had them join us, and several of those people have spoken up and made public comment. Right now, the other room is empty. We've had several people join this meeting at some point this morning. And we do, Mr. Hearing Officer, have at least one gentleman that would like to make public comment.
Okay, we'll proceed with that. Would the gentleman who wants
Larry Sontag.
Larry Sante, Mr. Sante, would you please identify yourselves and spell your name, and we'll swear you in?
Good morning, Mr. Hearing Officer. My name is Larry Sontag, Sonnntag. I'm speaking on behalf of the New Mexico Business Coalition.
Okay, and do you swear your testimony will be the truth, the whole truth, and nothing but the truth?
I do.
Proceed.
Mr. Hearing Officer and members, the concern is great with this type of effort to increase a fee up to 500% is my understanding. The funding for permits and fees that an agency has should be made upon operational considerations, not an effort to increase budgeting, which is controlled by the legislative branch of our government. So I would encourage that this not be moved forward. This type of increase in budget effort should absolutely be done through our legislature and not with a division or department, a branch of state government. And that concludes my comments. Thank you.
Okay, thank you. Ms. Jones, is there anybody else on the WebEx?
Would anyone else like to make public comment this morning? We have a couple of call-in users. Again, call-in user 3. Are you interested in making a comment? Just speak up. Call-in user 6. You might or might not know that that's the number you appear as, but if you are on the phone and would like to make comment, please speak up. Mr. Hearing Officer, I'm not hearing that anyone is willing to come on and make a comment.
Okay. I believe that will conclude the public comment. We've given everybody, I believe, a reasonable opportunity to call in, or if they were on the wrong link, to get transferred to the right link. So at this point, I'm going to declare public comment sessions to have ended. And I believe that brings us to the point of discussing post-hearing matters. My understanding of the board's decision yesterday was that closing arguments and post statements of reasons from the parties will be due in, I heard 30 days from yesterday, but that falls on a Saturday. The 27th would be this 27th of July. So as under the rules, those would be due July 29th, Monday, July 29th. And then I've been requested to prepare a hearing officer's report within a reasonable period of time after that. And I will do so and use the next 30 days as a guideline for getting that done, which would be, on or about August 28th, or at least we'll say before the Labor Day weekend. I'll target for getting it done before that and filed. Under the rules, the board then has 60 days from the filing of the hearing officer report to make a decision. So the board will have, it appears the board will have until the end of October to make a final decision on the matter. I am informed that it'll be a couple of weeks before we get a transcript of the proceeding. So, but that the WebEx video will be posted no later than Monday. So council will have that to rely on in preparing post-hearing submittals beginning Monday. And then the transcript will come in after that and be available, be filed and be available within approximately 2 weeks. I don't see any reason to keep the record open beyond today. I will keep it open until 5 p.m. today for additional written comments, just in case there's someone who is out there that hadn't had a chance to comment and contacts Ms. Jones. She can direct them to prepare a written comment, which can be submitted by email or on the NMED website or by regular mail. I'm sorry. Yes, a member.
Hearing officer, do we not need to keep the record open for the statement of reasons?
Yes, well, I clarify, good point. It will be kept open for the evidentiary record will be closed as of 5 p.m. I should have clarified that. 5 p.m. today. The record will remain open for post-hearing submittals in accordance with the schedule I just outlined and the board established. but will be open for those purposes only, not for the submission of additional evidence. Are there any other matters to come before the hearing?
Mr. Hearing Officer, just on behalf of the Mining Association, I'd like to express our appreciation for all of the board members' attendance and attention here and your good questions. We know that you're not highly paid in these positions, and particularly contested rulemakings can leave you with a lot to sort out. So we really appreciate your work, and Mr. Hearing Officer, yours as well. Thank you.
Thank you for that, Mr. Miltenberg. Seeing no additional comment, I will declare the hearing adjourned and turn the meeting back over to Chair Sweeney.
Thank you, Mr. Hearing Officer. First, before I continue, I just want to thank Mr. Virtue for guiding us through the hearing. And I also want to thank NMED Council and staff for being here, as well as the independent IPA and NMMA legal counsel and staff. And thank you for bringing to light some of the information that you brought over the last 2 days. It'll help us consider this proposal. And thank you for your presence as well as those on the platform. Appreciate the public comments and appreciate the interest and the engagement, as well as from our New Mexico legislators and our leaders. Thank you so much for participating in this process. With that, the board will not make a decision today, just to be clear, but we'll meet at a later date to deliberate after, as Mr. Virtue defined the calendar and the next steps in this process. And so with that, we'll close that item and go on to our next agenda item. Thank you all. Our next agenda item, well, we're actually going to go to number 6, and that's a litigation update for D-101-CV-2023-01038. And I believe that we will need to enter into closed session. Is that right, Ms. Padilla?
That is right, Madam Chair. And
thank you, Ms. Padilla. And therefore, I want to look to my fellow board if anybody wants to propose a motion to enter into closed session.
Chair, if I may, this is Council Miller.
Yes, Ms. Miller.
We did send an email earlier regarding a potential memorandum, a written memorandum for the board rather than a discussion in closed session. It's been a long couple of days, and if the board would prefer something in writing that we could discuss with attorney-client privilege, we can do that, or we can go into closed session today. It's up to you folks, but I wanted to give you the option just in case.
Okay, thank you, Ms. Miller. I'll look to my fellow board members on your thoughts. Sure. Hold on one second, Ms. Miller, and folks on the platform. Our interpreter staff would like to make an announcement.
I would just like to thank the interpreter team, and the hearing that you were hired to interpret for is over. It's concluded, so you may log off.
Thank you for that. And I also want to thank the interpreters as well as our court reporting staff. Thank you so much for being here. And as well as any other support staff that's assisted us through this process. Is there any other logistical items that I need to take into account looking at the support staff? If not, I want to look around and see if thoughts about are going into closed session or just relying on written on the written memo from our legal counsel. Yes, Member Hunker.
I would be fine with a written update, which would avoid the need to go into closed session today. Just my feeling on it.
Thank you, Member Hunker. Member Garcia also.
Yes, thank you. I agree.
And I see Member Bitzer, your hand is up. Do you have any comments?
My hand went up out of concern about how those of us online would participate in closed session. But if we're going to go with the written memo version, then I guess that's a moot point. So, and I'm in favor of that as well.
Thank you, Member Bitzer. Yes, Member Ely.
Ms. Miller, did you send an attachment with the email, or is that coming at a later date with the litigation update?
Thank you, Member Illy. Yes, we were going to send the memo later this afternoon, but first wanted to check with you folks if you wanted the memo. But yes, we can get that to you. And then I also noted in the email that we're happy to put pending litigation or litigation updates as a standing item on your agenda, so that every time you guys have a meeting, it's an option for discussion.
If
Yes,
I may,
Member.
one more question. So what's easier for you? If you haven't written the memo yet, would it be easier for you if we went into closed session?
It's, I'm in favor of either one. Ms. Padilla is going to give the update on the Atencio case specifically. It's my understanding that there's not going to be a ton. It's not going to be, a 12-page memo, fortunately. And that we're also happy to discuss it further once you guys have read and digested a little bit. And if you have those other questions, it might be better for you guys to have some time to review it than to dump it all on you and expect questions today. So either one is easiest. It's really what's easiest for the board. I do have Member Bitzer's same concern regarding, how we're going to go into closed session virtually. It can be done. It's just kind of wonky. So.
Yes, thank you, Ms. Miller. Is there any other comments or questions from the board on this? It seems like the consensus is just to rely on the written memo for right now. Okay, I see some head nods on our side. So Ms. Miller and Ms. Padilla will await your written memo later today, and then we'll have the standing item on our agenda for our future meetings.
That sounds good. Thank you, Chair.
Thank you. Therefore, we will go on to our next agenda item, which is agenda item number 7. That's the next meeting and upcoming matters. So for looking to Ms. Jones and our legal counsel, I believe I'm tracking that we have an upcoming meeting in July.
That's correct. It would be Friday, July 26th, and it's scheduled in this room. I don't have any agenda items at this point.
Thank you, Ms. Jones.
Madam Chair, Leslie Padilla here. I do think it would be wise to at least tentatively have that date as a meeting, because especially with some deadlines in the Atencio lawsuit that we'll mention in the memo, it may be helpful on that day to have a discussion that would be, of course, in closed session, because that would be in advance of one of the next filing deadlines on behalf of the defendants.
Thank you for that, Ms. Padilla, and that's sort of what I was tracking in my head as well. So we will have a meeting scheduled in this room on July 26th. Yes, Member Garcia.
Yes, did you say you received a notice of petition or something recently?
It was this item that we were tracking that we would have to have some to bring to the board.
Okay, thank you.
Is there any other upcoming matters that we need to discuss and keep on our radar?
Madam Chair, just one more thing.
Yes.
I will not be here for the July meeting. I imagine you'll have a quorum without me.
Thank you for that, Member Ely. And I want to look to Ms. Padilla. Given that, is there anything that we need to make sure, given some of the notices that we've, that the department has received regarding the potential agenda item that we should discuss with Member Ely here?
Yes, thank you, Madam Chair. No, I don't think anything requires discussion as much as just an update from us as to what has happened in terms of the recent activities in the Atencio lawsuit, because that is what both Ms. Miller and I would like to do, is just make you aware of the current status of those cases. But at this point, I don't think there would be any need for discussion. And of course, after we do send this memo, if anyone does have any questions, you can certainly call either of us or email us.
Thank you, Ms. Padilla. Okay. With that, it looks like we've got our next meeting in July. And then if there's no other discussion topics for item number 7, we can go right to item number 8, which is adjournment.
I will move, we adjourn.
I'll
Thank you,
second
Mem-
that.
Thank you, Member Hunker, for your motion, and Member Bitzer for your second. With that, I'll ask Ms. Jones, can you do a roll call vote on Member Hunker's motion?
Yes, on the motion to adjourn. Member Bitzer, how do you vote?
I vote yes.
And Member Ely?
Yes.
Member Garcia?
Yes.
Member Honker?
Yes.
Vice Chair Trujillo? And Chair Sweeney?
Yes.
We can be adjourned.
Thank you, Ms. Jones, and thank you for everybody on the platform as well. Have a wonderful rest of the Friday and wonderful weekend.
Thanks, everybody. It was wonderful to meet all the board members.
I will send you